In Malaysia, rules that govern an advocate and solicitor includes Legal Profession, Practice and Etiquette Rules 1978, Legal Profession Act 1976, Solicitors Accounts Rules 1990, and Bar Council rulings. Generally, duty of lawyers to its clients is called as fiduciary duty. The term fiduciary comes from the Latin word fiducia, which means trust or confidence. In a fiduciary relationship, client puts his or her faith, dependence, and trust towards the advocates and solicitors. Advocates and solicitors hold the responsibility to show loyalty to them. On top of that, they also owe duties to the court in which they are prohibited to behave in a way that contradicts the law. Rule 36 laid down that an advocate and solicitor must make every effort to prevent his client from doing things that he or she should not do, particularly with regard to his or her behavior toward the court and judicial officers, witnesses, and parties. If a misconduct has been engaged by the client, the advocate and solicitor shall terminate the relationship. Quoting from the case of Rizano Zakaria in 1999, Judge Augustine Paul in his judgment held that whatever an advocate or solicitor's obligations to his client may be, his duty to the court is paramount in the administration of justice. Besides, in the case of Chia Cheng Hock against PP 1986, it was quoted by Judge Lee Hoon Ho that it is thus a mistake for an advocate or solicitor to believe that just because he is operating on his client's instructions, he cannot be held in contempt anytime he says or reads something based on those instructions. Following the case of Yusuf Ali Khan against Sid 1970 in Attorney General of Malaysia against Manjit Singh Dillon 1991, it was held that a legal practitioner can also be held in contempt of court even for professedly used language in the discharge of his functions as an advocate.
Hello, my name is Nandini, daughter of Arunu, and my student ID is A167208. The advocate and the solicitor-client relationship is the premise of the professional practice. It is a relationship which clearly carries reward, yet which additionally conveys with its enormous pressure, risk, and responsibilities. Every lawyer has an obligation to his client to fearlessly raise each issue, ask every question, and advance every argument, however disagreeable, which he thinks will assist his client's case. Yet, an advocate and solicitor shouldn't deceive the court. He should not lend himself to projecting slanders on the other party or witnesses for which there's no adequate premise in the data in his possession. An advocate and solicitor ought to consistently extend respect towards the court. An advocate and solicitor needs to remember that the nobility and the respect maintained towards the judicial office is vital. Rule 36 of the Legal Profession Act 1976 is crucial because, as we all know, the court provides fairness and consistency. An advocate and solicitor ought to show respect for the overall side of law and for the people who serve it, including the judges, other counsels, and public authorities. That being the case, an advocate and solicitor must utilize his greatest effort to keep the clients from doing things which the advocate and solicitor himself should not do. Where a client endorses such wrongdoing, the advocate and solicitor must terminate the relationship. The Rule 36 has been well illustrated in the case of Dixon Koh Soon Hong and Koh Jiak Chu and another. That's all from me. Thank you.
Hello, my name is Nur Shayani and I will proceed with the issue of this case. It is whether Mr. Dorai's failure as a solicitor to Dixon Ho Soon Ho in making full disclosure to the court and the act of concealing important facts constitutes contempt due to its interference with the administration of justice. The court concluded that Mr. Dorai was acting under his client's instruction, but it can never be a defense as it is embarrassing for a senior advocate and solicitor to even resort to such defense used by a layman. In referring to Zainur Zakaria, an advocate and solicitor shall not simply assume he cannot be punished for contempt by reason of merely following his client's instruction. Mr. Dorai had filed a false and misleading affidavit and he is to be sentenced after hearing the mitigation for his act of contempt. If a contemptor is permitted to be proceed in another hearing to obtain relief of a similar subject matter which he has applied in the court that he has been accused of, while his contempt has yet to be cleared up, then this would bring about uproar in the administration of justice. The court agrees that the standard of contempt which he carried out to frustrate the proceedings before this court is beyond reasonable doubt and to be sentenced to a fine of 5,000 ringgit to be paid in default of 1 month imprisonment. Finding of contempt against a legal advisor is already a discipline itself, as this intently identifies with his reputation as an advocate and solicitor as a whole. It is therefore a fallacy for an advocate and solicitor to assume that just because he is acting on instruction from his client, he cannot be punished for contempt whenever he is saying or reading something based on such instructions. That's all from me. Thank you.
Assalamualaikum and a very good day. My name is Yasmin and I'll be explaining regarding the loophole of our topic, which is Rule 36. Rule 36 expressly stated that one of the duty of advocate and solicitor is to use all of their power to prevent their client from doing things that themselves would not do, especially conduct toward the court. We are made aware that the duty of advocates and solicitor to the court surpasses their relationship with the client. This could be proven when the legislation allowed the advocates and solicitor to terminate their relationship with the client if the said client constantly conduct horribly. In the case of Zainur Zakaria, it was held that whatever may be the duty of advocates and solicitor to his client, the advocates and solicitors' duty to the court remain paramount in the administration of justice. From the legal standpoint, the limit in Rule 36, where it is stated that the client must be prevented from acting such that advocates and solicitor should not do, is vague. The phrase himself ought what not to do is not clear to set boundary to fellow counsel. As we all know, an advocate and solicitor has a high standard of conduct imposed on them. So, one of the loopholes of the Rule 36 is the lack of clarity.
Having explained earlier, let's revise the gist of Rule 36 of Legal Profession, Practice and Etiquette Rules 1978. Under this rule, it places a paramount duty by an advocate and solicitor to always remember their duty toward the administration of justice. In simpler words, this paramountary duty override their duty towards their client. For example, an advocate and solicitor must refrain their client conduct from obstructing justice. They must always be aware that their client's conduct, which may be deemed as such. Acting on instruction cannot be used as a free pass to exclude the advocate and solicitor from being responsible. I would like to quote a case. It is a correct statement of the law to say that the solicitor should fearlessly conduct the cause of action, having both his duty to the court as well as his duty to his client. Now, advocates and solicitors do have the responsibility to advise their client, and in the event where their client refuses to do so, he should decline to act for their client. Why this is very important? Because the failure to decline such a relationship may amount to contempt of court. In the case of Yi, Chang and Co. Limited, 1958, court briefly explained as to when a solicitor must execute their duty to advise his client. The keyword in this case mentioned, it must be immediate right after the advocate and solicitors have the knowledge in mind.
Hi, I am Pakdi Elki Aisin, A167725. So, for the conclusions, an advocate and solicitors owe the duty to uphold justice in society, the rule of law, and act in their client's best interest. Based on our study, we believe that an advocate and solicitor must perform their duty at very best level by advising their client to not do anything inappropriate to the court that may interfere with the administrations of justice and may amount to contempt of court. So, the lawyer must be by any means prevent their clients from leading them to do any misconduct towards the court. However, in judging the duties, an advocate and solicitors shall also abide by the rules prescribed under the Legal Profession Act 1976 and maintain the ethics and professionalism as a legal practitioner. It is also important for advocates and solicitors to abide to Rules 36 in totality when they represent their client, as they owe the duty not only to their clients but also to the court. To conclude, on the issue of whether or not an advocate and solicitor may be liable for any misconduct which is instructed by the clients, We submit in the affirmative because the lawyers should follow every single rule, and any act that may interfere with the justice administration should not happen in the first place. Hence, we humbly suggest that such duty should be exercised cautiously by the advocates and solicitors. That's all from us. Thank you.